Alan Parker versus Megan Plant and Steve Plant.
Good morning, Your Honor.
Good morning.
That's actually three separate motions. One is the easy one is a motion to establish a special needs trust for Steve Plant by way of updates.
Are these folks behind you associated with this case?
On April 25th, the property, there was the remaining property in this partition actually got sold.
What is your name?
William Bell.
Okay.
These are some of the successors in interest to Megan Plant Vale, who died untimely last summer. They were substituted in along with Miss Vale's surviving minor children. Mr. Potter over here is the appointed guardian ad litem for them. So we actually do have everybody in front of the court this morning. The property was sold at auction. That auction was approved by order on May 11th. All the sales have now closed. We are done with real property. All that's left is a common fund. Mr. Steve Plant is a disabled adult individual. He's institutionalized, has been for years now. It is reasonably anticipated that he either does or will need to qualify for various governmental benefits that are contingent upon his status of quotes resources, close quotes, as defined in the PALMS manual of the Social Security Administration. If he were to receive his share of the remaining common fund as eventually determined, it would likely disqualify him for that. And so we have filed a motion to establish a special needs trust, which will of course prevent those from being included in his resources for those purposes, subject to any legal requirement for reimbursement upon his death.
And what is your connection to this situation?
I got several papers from all the motions, and I had some things I wanted that were written down on the motions file that I wanted to address. For
This is the special needs trust, of course, is not does not implicate any of the other parties. It says necessary to get this done.
Special needs trust only only affects rather the individual that is
Correct.
Mr. Steve Plant, correct? And you have no connection with Steve. Wait a second. You don't have any connection to Steve Plant, correct?
Correct, Your Honor.
All right. So your request is that a special needs trust be created to put the proceeds of anything that Mr. Steve Plant is receiving into the special needs trust.
Sheriff Davis, his cousin, is appointed conservator, and the way the trust is drafted, the conservator ex officio from time to time will be the trustee of this trust. Conservators, because that will result in a constructive receipt by Mr. Plant of the money, which would sort of blow up the whole purpose of doing a special needs trust in the first place.
But with the fact that there is no other person to really be affected by this creation of the special needs trust, and that there is demonstrated a need, and I'm familiar with this case, so I'm familiar with the fact that there is a need, then I am going to grant your motion to create a special needs trust.
Thank you, Your Honor. The next motion, of course, now that the real property has been disposed of, and the entire common fund is in the possession of the clerk and master, this is actually the ending point at which the statutory claims of counsel to be paid from the common fund would logically end. Anything from this point forward would necessarily be in the nature of representing the individual interests of the parties rather than the collective interest of everybody in getting the property smoothly disposed of. And with that in mind, I have presented my motion for the final approval of fees to be paid from the common fund as permitted by the statute. I understand Mr. Potter, similarly on behalf of the minor children, has also presented a similar motion, and we would suggest that award is would be timely and reasonable.
All right, I have reviewed both of your motions. Let me find out what these folks here are asking. Come up to the podium, please. And I'm sorry, but I'm going to ask you your name again.
William Bale.
William Vale. Okay. And Mr. Vale, what is your connection to this situation?
With the estate,
Yeah.
I was the husband and widower of Megan Vale. I was my wife, passed away in July 25.
Okay. And what exactly are you here today asking?
I was, there was 2 commercial properties, lots that were with the estate. And I know the court had ordered for Bill Collier to do the auction. They ordered everything to be sold the day of the auction. Those 2 properties were not in the auction. I've not seen anything about them being sold. And I know that Megan and I had hired Mr. Potter originally when this first started low, when I first got involved in it. And we fired him. We paid him somewhere around $15,000. And already I was wanting to know, I am not familiar with the law office very well, so I know the attorneys are wanting their money out of the estate now. Was that's coming off the top? Is that going to be for who they the portion of who they represent? Is it their portion of the inheritance, or is it just coming out, and then it gets split up between the estate?
Mr. Let me first of all. So your 2 things that you're asking is, one is the fact that you're saying there were 2 commercial properties that were to be sold, but you're saying they were not included in the sale.
Sir.
All right. And then the second thing is you're questioning whether or not the attorney's fees that were being paid to the attorney for Mr. Were you representing the estate? Is that correct?
Your Honor, we appear to have introduced a conceptual inconsistency here. There is no estate. This was a partition action. Megan Plant Vale was one of the parties defendant. She died. Her estate, by the way, has never been opened or administered. Now, later this summer, we'll hit the 1-year claims bar date on that. But when she died, we of course had to suggest her death and then to substitute in her known heirs at law. And we actually published on any unknown heirs and devisees. And then we substituted them in last fall. Now, Mr. Vale is partially correct. The court did order the main piece of property located on Dye Road to be sold at public auction. Done. In the same order, those 2 quotes commercial lots, they're actually landlocked. There's no public access. They're very rugged. They're unimproved. In the same order, and I've slept since then, Your Honor, but I'm pretty sure it was the November 11th, 2025 order directed that those be sold by negotiated sale by Mr. Will Sanders of Bill Collier Realty and Auction. That was done. A motion was presented to the court, which was also heard on May 11th, to approve the negotiated sales of those, and those negotiated sales were in fact approved and have been closed. So, and when in fact those properties are now also disposed of, and their proceeds are also in the hands of the clerk and master.
And then the other, so commercial properties that you were questioning were not sold at auction, but they were instead sold by negotiated sale that was approved by the judge last month in May. And so that those 2 properties have been sold. So the second question is where the funds that are being paid or requested by the attorneys are being paid out of the portion of the entirety of the estate, or not estate, but the entirety of the proceeds, or whether just on one portion of that. So Mr. Regent, you want to address that point?
Your Honor, the applicable statute provides that those fees are to be paid from the common fund, which necessarily includes all interests of all parties. And of course, the mathematical effect is that everybody ends up bearing a portion of those fees commensurate with his or her interest in the common fund.
Mr. Potter, you had stood for a second. You
Well, I mean, to the extent that Mr. Bell mentioned my name, I'll say that initially I did represent Megan Plant in a partition action that was filed by Alan Kent Parker, who is on the side of this case. He was represented by Mr. Bob Thomason, and we did negotiate a settlement to that partition action, which left the property in question being owned only by Megan and Steve Plant. This Plant and I terminated our relationship. I disagree about the way that happened, but time passed and she passed away. The court appointed me to be guardian ad litem for her minor children for purposes of this. There's no conflict. There never has been conflict. And I have reviewed the paperwork that has been approved by this board and the orders for the sale, and I think it's in the children's best interest.
The explanation that's been given to the court, I find to be satisfactory, were paid by counsel in a partition action are to be paid from the common fund. And therefore, that's the source of those attorney's fees that will be paid. Mr. Potter's role in the initial stages of that situation is completely different than his role as the guardian ad litem for the children. He was appointed by court order to act on behalf of the children. So his request for attorney's fees is a legitimate request that we normally will take place in a partition action or any other case where there is a guardian ad litem. So,
Okay, well, the reason I brought that up, Your Honor, is because the money that was paid to Potter after Megan fired him was, we had started the logging of some of the property, and Mr. Davis wasn't actually appointed conservator at the time, so the checks were being mailed to Megan and of the logging, and she cashed a couple of them to pay Potter because as soon as she fired him, he immediately filed for, or immediately went after payment with threat of turning it over to collection agencies. So the money that came from the estate was paid to Potter.
well, all I can tell you is that as far as this court is concerned, those are two distinct and different situations, and therefore I cannot. We've given you the explanation for how that occurred, and it is a legitimate expense of the lawsuit and the common fund. So any issue you have regarding the payment that was made to Mr. Potter, that's not before the court in this situation. We're now just dealing with the disposition of these funds after the partition sale has occurred. So I appreciate you being here, but I think we've answered all of your questions.
Your Honor, there was a part of the motion was they said that the people that were renting the cabin that was part of the estate would be deducted from our portion of payment would be deducted from that. But I've seen no proof of where they paid. I'd like to see I'd like to be able to see physically where the renters paid the money over several years, not just the last few months where they paid the court. The account that was the money the court in over the last, because they were there for years. And I know they lived there for years without paying.
When did you file your motion that you're referring to?
That motion was filed. I read the motion. I believe Regan filed the motion. It was in part of the motion that he filed about the.
I'm sorry, repeat that.
Money from the renters that were living in the
I
cabin.
know, but when did you file a motion?
I did not. I was motioning they filed. I'm responding to that. He said that the money, half of the rent should be coming out of the.
So you haven't filed a motion?
No, I'm just responding to that motion.
Well, Your Honor, Mr. Vail, as a layman, is concerned, legitimately so, but he's actually getting a little bit ahead of the process here because the third motion that's before the court today is a motion to set this matter for final hearing to determine the interests of all parties. In the course of that hearing, proof will be offered. We'll be subpoenaing the tenants. Proof will be offered as to the matters that Mr. Vail addresses, and everything will be rehashed out. Mr. Vail mentioned money from the logging operations that was paid to Ms. Vail and somehow never got back into the court. That's actually been the subject of a prior order of the court to account for, and again, I'm gonna have to beg the court's indulgence since I've slept since I last looked at it, but it was on the order of about $35,000 that Ms. Vale did not account for. But again, that's all, we've got a common fund. Every dollar is divisible by 100. And that is the point at which that hearing is, the point at which all of these matters will come out and wash.
And there's a motion to set,
Yes, sir.
correct? And was it set at that motion for that motion to be heard? Has it been set, I guess?
Oh, no, Your Honor, that's on the motion to set is on the court for, is on the docket for today as well.
All right, Mr. Bell, what we're gonna do is we're gonna set a hearing date, and that hearing date will entail what you're requesting to find out.
Very good.
And Your Honor, I actually, I don't know about Mr. Potter, but I do have a proposed order on my page.
All right,
I don't have one, Judge, but I can submit it.
all right, if you'll submit your order.
Thank you.
When do we want to set this?
Would the court have any days in September or October?
Well, I'm back here in October. How long do you think it's gonna take to try the case?
Half a day, Your Honor, maybe, probably less. I mean, most of the issues involved are matters of
We've got stuff set
already
on
in
the
the record.
So we could do this thing.
second of October,
It works for me, Your Honor. 9 o'clock?
It works for me.
9 o'clock. All right,
Oh,
now, Mr.
sure.
Bell, I'm gonna suggest you might want to consult an attorney to make sure what your rights are and what you can and cannot do. If you're representing yourself, you haven't, you're not really necessarily a party to this action unless you have filed something. So you may be a part of the estate, but unless you're a named party, you don't get to participate in the hearing. You understand that?
Your Honor, they, Mr. Vale and Ms. Waketis, and of course the minors were actually formally substituted for this plan. It's just style.
It has been substituted. Well, I haven't touched this file in quite some time, so. All right, then we'll see you here October the 2nd.